What in the heck is reverse discrimination at work in California? I'm going to explain that and more in this video. Let's first cover the basics of reverse discrimination. Reverse discrimination isn't a legal term. That is a layperson term to describe a discriminatory situation that is inverted from what we traditionally think of when we think about discrimination. In California employment law, the Fair Employment and Housing Act, section 12940, subsection A, is the main anti-discrimination statute in the state of California. It makes no mention of reverse discrimination. Reverse discrimination, as traditionally thought, is when a less favored group, traditionally, such as African Americans, are now suddenly being promoted or being hired over a more traditionally favored group, such as Caucasians, simply because of their race. That is a very good example of what reverse discrimination means to most people. But this statute makes no mention of it. So is it legal or is it not? Well, let's talk about what the statute actually says. The California Fair Employment and Housing Act says that it is an unlawful employment practice for an employer to take any adverse actions against an employee because of a protected characteristic. Well, let's first talk about adverse actions. What does that mean? That means like firing, demoting, refusing to hire. That's bad things that employers do to employees. And you can't do that if you're basing that decision on a protected characteristic. Well, what the heck is a protected characteristic? Well, they're the things that we traditionally think of when we think of discrimination. Race, religion, gender, sexual orientation, disability, things like that. But in a reverse discrimination case, those roles are flipped. So let's talk about them now. Everybody's heard about the traditional protected characteristics, such as race, religion, gender, sexual orientation. However, in reverse discrimination cases, all those roles are flipped. So in a race case, it would be where a Filipino worker is hired at the expense of a white worker or a Caucasian worker, simply because they are Filipino. That would be against the law. A good one for religion is where an employee is hired, a Jewish worker, over a Christian worker. That would be against the law if the decision-making calculus was simply that they are Jewish and the other person, or that the person who was not hired was Christian. If that was the factor, then that would be against the law. Gender, where a woman is preferred over men. It's starting to happen sometimes in certain workplaces. Disability. That one's really pretty rare. The better example of is medical condition. I mean, you can imagine a scenario like this, where the hiring manager or the CEO or whoever's got diabetes, and they seem to really want to be around other people who have diabetes to the expense of people who don't have diabetes. That would be against the law. Sexual orientation, there's a lot of LGBT-friendly companies in the state of California, which is awesome. Unfortunately, sometimes those companies seem to prefer folks who are gay versus people who are not. Using anybody's sexual orientation as a basis for an adverse employment action is against the law in California. National origin. There's a lot of immigrants in California, which is awesome, and a lot of them are really go-getters, and they go start their own companies and they build up their little empires. Some of them, however, only hire people from the nation that they came from. And if you're making a decision, an adverse employment action against anyone because they are not from the country that you came from, that would be against the law. And California Fair Employment and Housing Act 12940, subsection A, is about discrimination. If you're using a protected characteristic in any way as a part of your decision calculus, the employer has broken the law. If you're the victim of reverse discrimination in one of these categories or any of the other protected categories in California, what should you do about it? Well, most people contact a lawyer and file an employment lawsuit or discrimination lawsuit. Well, why? Well, because there are damages that need to be remedied. Specifically, in an employment case, let's say you were making $100,000 a year and then you get fired because you're straight or you're Christian or you're Caucasian or whatever. And you're not making $100,000 a year anymore. That's a very tangible economic damage that a jury can measure. Similarly, if you're fired because of one of these protected categories, oftentimes there's a tremendous amount of emotional suffering that comes with it. And those emotional distress damages, pain and suffering damages, are compensable as well. Emotional distress damages in discrimination cases can often be much larger than the economic damage picture. And finally, if you show you got a really good case and you prove that the company acted with malice, oppression, or fraud, you can win punitive damages. Punitive damages are those meant to punish the defendant, to deter them from ever doing it again. So those damages, when you combine them all, can be quite substantial. And those damages are how the justice system tries to right the wrong and tries to deter bad behavior, discriminatory behavior from ever happening again. I really hope you found this video helpful. Take care.